Hello, my name is Surya Dharma Samosir and I'm from University International Batam, and I want to tell you about my topic. My topic is the characterizations and the connecting factors. Before I got into the cases, first of all I want to tell you about the meaning of the topic it is. The first, the characterizations. Characterizations is simply an interpretation or application of the rules of private international law in a concrete case, and the conceptions of these rules must therefore be conceptions of an absolutely general characters. The connecting factors. Connecting factor mean is a link between a person and a legal system or rules that will apply to him in specific contexts, such as the validity of a marriage, matrimonial causes, legitimacy, succession, and taxation, or domicile. Okay, so I got into the case one. So in this case, that there are Denpasar District Court ruling under register number 172 in year 2014 regarding divorce of foreign national in Indonesia is one of the related case related to international civil law. This lawsuit was filed by a husband who called himself Thomas, who is a South African citizen, holder of passport number M000096351, and has a limited stay permit card in Indonesia. The issue of this case is issued by the Ngurah Rai Immigration Office, currently based in Bandung, Bali. Thomas and his wife had been married since December 20 and in 1975, and explained in the complete marriage certificate issued by the Ministry of International Affairs of the Republic of South Africa on December 12, 2005. And then since the marriage took place until now, they have not been blessed with a child. It has been 10 years since Thomas and his wife have not lived in one house, but husband and wife work together in the hotel business, but they work in a different hotel, so they have to separate. They have to travel abroad individually, which results in them rarely seeing each other because it has been spread for 10 years. In the sense that they have not lived in one house, then Thomas filed for divorce to the Denpasar District Court, where he and his wife are domiciled now, and his wife approved it. The next is Thomas divorce against his wife was included in the case of international law because there are some foreign elements, namely Thomas and his wife, who are citizens of South Africa. Wherein analyzing this case, the focus was on the divorce lawsuit filed in the Denpasar District Court, but the marriage of the two couples took place in South Africa. From the case description above, they try to analyze with the traditional link point theory, qualification theory, lex pori and lex cause. According to Bayuseto Harjowahono, link points are facts in a set of case facts that show the interrelation between the case with a particular place, and therefore create the relevance between the case concerned and the possibility of an international legal system or rule in place then. We first determine what the primary linking points of the case are. So, the primary link point of the case include the citizenship. Okay. Based on the case above that I have tell you, so we start to characterize. So we have to know what is his domicile. As you can see, he lives in Bali, but he has a nationality of African. So the citizenship, because Thomas and his wife are married couple who are citizens of South Africa, and at the domicile, Thomas and his wife permanent residence is in Bali. So the domicile is included as the primary links point in this case. And then the legal action. What is the legal action? The third point is include as the primary link point because the divorce lawsuit filed by Thomas against his wife was filed in the Denpasar District Court. After determining which is the primary link point, then we determine what comes the secondary link point, which becomes the second link point is the law of citizenship, or we could say lex patriae, because Thomas and his wife are foreign citizens. And then from the final story of these cases, based on reinforced by the opinion of Sudargo Gautama, when a divorce or a separate life cases is filed, one of the conditions detailed below must be fulfilled. The defendant has his habitual residence domicile in the country where the divorce is pronounced. After we find the lex valere of the case, the next step is to determine the lex causae of the case according to Article 18ab, which contains the form of each act is determined according to the law of the country or place where act was committed, or we could say locus regit actum. But based on my topic and from the case, we should characterize the what act that he do, and we could say that he has a nationality of an African, he has a domicile of Indonesian, for the example place is Bali, and he has married to his wife in Indonesian. So, and then he has the lex patriae in the Indonesian. So the lex valere is and then can determine the lex valere from the description of the legal fact above is Indonesian law, because he married Indonesian, and the divorce means which is the divorce in Indonesia. And why we call it the private international case, because it has a foreign element in it, such as he's a foreign, he's not from Indonesia, but he from Africa, but he married in Indonesian, live in Indonesian, and then after 10 years they go apart, they don't have anything more, and then they want to divorce. So where is the divorce? They choose Indonesian. Can they do that? Of course they can. And then the final judgment of the international fight. So after we go through the characterization, we have admit, for I repeat again, the nationality of the Thomas is African, and then the domicile of Thomas is Indonesian, but the marriage is done in Indonesian, and then the they they after the marriage it has been written in Indonesian, and then the divorce, where is the divorce? From the sound of the case that I got, the lex causa of this case is international law, is Indonesian law, because what? From the case analysis, it can be concluded in resolving divorce case submitted by foreign nationals in Indonesian court can be settled in Indonesia, provided that the judicial process is in accordance with formal law and the statutory regulation in Indonesia. In addition, the Denpasar District Court has the authority to examine and try in a foreign citizen's divorce case based on the place of residence of the defendant, or we could say forum break, namely in Indonesian, and the consideration of the Supreme Court, which grants the South African citizenship divorce suits in accordance with the principles of civil law, international law, the material law used in Indonesian law as the basis for examining a claim filed by the plaintiff. And then, what is the connecting factors? We could say the connecting factors as I say from the first. The connecting factors means is a person's go through a legal statement in something legal, and then you could see the marriage, you could see the domicile, you could see the nationality. So the connecting factors of Thomas is, we could say, his nationality, and then his domicile, and then his marriage, and then his divorce. From this case, I found four connecting factors of Thomas: nationality, domicile, marriage, and divorce. And second case is the agreement between IPB and America. So IPB entered into an agreement to send 1,800 monkeys to America, and the monkey will only be taken by their children, and the baboons will be returned to Indonesia. The price of the coupon was agreed at 80 million, and the United States only needed its children and had to have children in the United States. When the plan's position was still in Switzerland, a monkey was dressed and released, giving birth to his child. Because the mother had been paralyzed and died, the veterinarian of IPB injected the money to death because of pity. Lawyer of the United States is demanding IPB on the basis of the animal protection and is deemed not to fulfill his achievement perfectly and to kill a monkey child. On one hand, monkeys in Indonesia are no more pests, whereas for the United States there are animals that must be protected. But the fact is, IPB entered into an agreement with the United States to send 1,800 monkeys to America. The monkeys would only be taken by their children, and the price of the child was 80 million. America only needs its children and must have children in the United States. When the aircraft positioned in Switzerland, a monkey stressed and released gave birth to his child, and its mother has been paralyzed and died. Veterinarians of IPB inject dead monkeys out of pity. The lawyer of America demanded IPB on the basis of animal protection and was deemed unsatisfactory and killed a young monkey. Monkey child for America is a protected animal. So the primary links are the factors and circumstances that show that we are dealing with events of international civil law, or the factors and circumstances that show that a relationship or event is an international civil law event. In this case, the primary link is the nationality of the parties, where the plaintiff is a lawyer who is a citizen of the United States, while the defendant is a veteran from IPB who is an Indonesian citizen. The secondary link is the factors and circumstances that determine the law of which country must apply in an event of international civil law. In this case, the secondary link point is because from the agreement between IPB and the United States, there is no legal choice or forum choice that is explicitly regulated in the agreement. The secondary link point is more than one, namely, number one, the lex loci contractus. So, where is the place of the law is been made, and then second, the lex loci solution is where is the solution place of this case, and then the third is the lex loci delicti commissi. So it means that we are using of the place law in the accident place, and then the fourth is the most characteristic connection, where is the mostly appears of a victim that in this case. So if we talk about the case, what is the applicable law? Based on the lex loci contractus, the applicable law is in Indonesian civil law because the agreement was made in Indonesia. But if we see based on the loci solution, the applicable law is the law of the United States of America because the agreement is implemented in the United States, namely the promised monkey cops must have children in the United States. But if we see based on the lex loci delicti commissions, the applicable law is Swiss law because the unlawful act of injecting a dead monkey is promised to be carried out when the aircraft is above the territory of the Swiss country. So, if we see based on the most characteristic connection, the applicable law is Indonesian civil law because the most prominent party is IPB or Indonesia as the ape seller, because IPB must submit apes, care for the apes well until later the apes are handed over to the United States, and in the sale and purchase agreement the most prominent or dominant party is the seller in this case. So we talk back about the characterization and then the connecting factors. So what is the connecting factors between IPB and American? So there is four, as I said before: the loci contractors, loci solutionists, loci delicti commissions, and then the loci most characteristic connection. So we have four characterization, and then the connecting factors is where Indonesia and American have made the agreement and where the agreement should be finished, but where the agreement has been accidentally. So that's the connecting factors of this case. Okay, the third case is the marriage of Yunisara and with an Australian citizen. The marriage conducted by Yunisara, an Indonesian citizen with Australian citizen who has married in Australia because they did not get the blessing of the parents of Yunisara. After the marriage was held, Yunisara and Siahaan had two sons, Dido and Lexi, and right at the age of the 20th marriage, they feel inappropriate because Yunis still lives in Indonesia. So the husband filed for divorce against the High Court in Indonesia and requested that the child of the two of them be raised by Siahaan. Before the lawsuit came into the Jakarta court, Siahaan has passed away and left the testament that the assets owned by the Siahaan were given to Lexi and Stefan. the adopted son of the Shah in Australia. The testament was made by Shah during his business trip to Europe, right in Germany. So in this case, we can see that a legal act has been carried out, namely the marriage and creation of testaments in Australia with marriage of different married citizens, and the making of testament in Germany by Shah. Based on our national law, material marriage must be carried out in accordance with the Indonesian Criminal Code and Marriage Law Number 1 of 1974. Because it is done in Australia, both materially and formally must be resolved by Australian law because it is done by Australian law. So in this case, we could conclude that we can characterize that Unisara has a nationality of Indonesian and that Shihan has a nationality of Australian, and that they both get married, and that's the connecting factors. They get married together in Australia, and then they have son, and then after that they have some problems, and then they have to divorce, and then divorce in Indonesia, and that's the connecting factors. And then but in the middle of the divorce, the Siahaan has passed away, and then the assets of Siahaan is fall into his adopted son, like, and then that's also the connecting factors in this case. So that's what I can tell you about the characterization and then the connecting factors of the third case of me. Okay, we got into the fourth case of the main topic. This is the case of Anton versus Batolo, the Maltese marriage case in 1889. The principal case is when a couple of British citizens domiciled in Malta, or a British colony, and having a wedding in Malta. Then, after the marriage, they moved to Seattle and live in Algeria, or French colony, and obtained French citizenship. During her life in France, the husband bought a plot of productive land in France, and then the husband dies. After that, the wife demands one full portion of the land produced. The case was filed in a French court. Okay, based on this case, some of the connecting factors that appears between the set of fact above, that Malta or in a British colony has a place for marriage, has a local celebration as a primarily France, or we can say Alsace is domicile, or we can say lex domicili, and citizenship after marriage, or we can say lex patriae, and where the land or object remains, or lex cite, and where the case is filed, or lex fori. The case settlement process is, in this case, because feel from the forum there is a primary link point, namely Malta as lex locus celebrationis as a foreign element involved in the case. The judge, in determining the law that should apply lex causa, will see that there are two rules that are basically equally valid both in English law and French law, namely, first, the issue of inheritance of land must be subject to the law of the place where the land is located, based on the lex solicitae principle. And second, the issue of windows demands for the right to marital property or matrimonial right must be regulated by law from the place where the parties domiciled at the time the marriage was formalized, or we could say lex loci celebrationis. But the issue for judges, the above set of facts by France internal law is qualified as a matter of inheritances, or we could say section of land, whereas by British international law it is qualified as a matter of claim for windows on marital property, If the case is qualified based on lex quorum as a matter of inheritances, then the widow has no right to inherit her husband's inheritance. But if it is qualified based on lex locis liberationis as a widow's claim on marital property, then the widow has the right to produce the land as marriage property. This is where the issue of qualification conflict arises. Decision of French judges. The French judge finally decided that these cases must be qualified as a matter of matrimonial property. So it appears that judges do qualification based on English law. In this case, is considered lex causa. Based on the theory of qualification from the Anton versus Bartolo case, it appears that in the question is qualification in a case must be based on what legal system. This question also drives the board of various qualification theories. What will be discussed in this discussion are their theories. The first one, qualification based on lex ori, qualification are based on the lex causa, gradual qualification, analytical or antonymous qualification of international civil law. So, based on the case above that I have told you, I have plenty explanation about the theory that are planted on this case, but the conclusion of the case is the lex force legal rules are best known to the judges, so that the case is easier to resolve. Because of this theory sometimes creates injustice, because qualifications are carried out by using measures that are not always in accordance with the French legal system that should be enforced, or even with measurements that are unknown to the foreign legal system. Okay, this is the last case of my topic, and then in this case the title is the Ogden versus Ogden in 1908, and the case position is Philip is a French citizen residing in France, and then he is 19 years old, and then he married to a woman who is an English citizen named Sarah. And then Philip and Sarah marriage took place and was formalized in England in 1898. And then Philip is married to Sarah without the permission of Philip's parents. This parental consent is required by French law. And then in 1901, Philip went home and then filed a cancellation of marriage in France on the grounds of marriage without parental consent, and the request was granted by the French court, and Philip later married a French woman in France. So he sues Phillips in England because Phillips is considered adultery and left his wife abandoned. Then she claim was rejected due to jurisdiction reasons. And then Sarah, who is already feels not attached to Phillips, remarries Ogden, a British citizen. And then Sarah and Ogden's marriage took place in England in 1904. And in 1906, Ogden considered that Sarah was still married to Phillips because under British law, Sarah's marriage had not been considered null and void because the French court decisions was not recognized in England. And then Ogden, because he knows Sarah is still a marriage with Philip, filed a request to cancel the marriage with Sarah on the legal basis that his wife has polygamy, and the application is filed in the English court. Dispute resolution process in resolving this case must be decide beforehand is, are Phillips and Sarah marriage considered valid or not? In this connection, the links point to English law as lex local celebration is because Phillips and Sarah marriage took place in England, and point to French law as lex patrie because Phillips is a French citizen, and lex domicile because Phillips is domiciled in France. In this case, the British rule states that the essential requirement of a marriage, including legal ability of a man to marry, legal capacity to marry, must be determined based on lex domicile. And then the second, the formal requirement for a marriage must be regulated by lex loci celebrationis. Meanwhile, if in Article 148 of the French Civil Code is observed, it can be said that the provisions concerning the obligation contained therein must be considered as essential requirement for a marriage. So, in an Article 148 CC states, a boy who is not yet 25 years old cannot marry if there is no permission from his parents. So, for French law, the lack of parental consent should have caused the marriage to be cancelled between Phillips and Sarah. But in reality, the English judge ruled that the marriage between Phillips and Sarah was declared invalid because the parental consent under British law was considered a formal requirement, and by law, the marriage was still considered valid because it was considered to have fulfilled the essential provisions or requirement of English law as lex loci celebrationis. Because of this, marriage between Sarah and Ogden is considered invalid because it is considered polygamous and must be declared null and void. So Ogden application was granted by a British court, and from the English judge's way of thinking, it appears that he qualifies parental consent based on his own law alone, or we could say like story, based on his own law. So the provisions of Article 148 CC as a lex causa are qualified based on the lex 40. Thank you. This is my topic about the characterization and the connecting factors in private international law. I hope you enjoy it.